My name is Callan O'Connor with my associate Catherine Grisham. We'll be representing Trinity Lutheran Church and Trinity Lutheran Church v. Sarah Parker Pauley. Trinity Lutheran Church has a daycare associated with it. This daycare applied for the Playground Scrap Tire Surface Material Grant in 2012. Although it was otherwise qualified for the grant, it was denied because of the Missouri Constitution, which states, "No money shall ever be taken from public treasury directly or indirectly in aid of any church, section, or denomination of religion." Which this means is that though the church was overall qualified, they are denied based on their associations with the Lutheran Church. They sue under the Equal Protection Clause of the 14th Amendment as well as the First Amendment's protections of freedom of religious exercise and speech.
We are positing that the First Amendment's Establishment Clause does not prevent funding for a church playground under the ruling of Lemons v. Kurtzman as well as Agostini v. Felton. Though the Trinity Lutheran Church Daycare incorporates daily religious activities into its programs, the playgrounds themselves are not inherently religious. And thus the playground funding is neutral. Playgrounds are also a child benefit as understood in the court cases of Cochran v. Louisiana State Board of Education and Everson v. Board of Education in the Township of Ewing. In the case of Cochran v. Louisiana, the court case ruled that the state could tax because they benefited the children with school books free of charge, regardless of their religious affiliation. This set precedent for Everson v. Board of Education, in which the court ruled the New Jersey law providing reimbursements to parents, religious or non-religious, whose children rode public buses was constitutional, as the New Jersey law was not a violation of the Establishment Clause, and it benefited the children. Both of these cases allocate the use of public funding for religious groups, creating the basis of the child benefits theory. This allows for governmental or state aid to religious schools or associations, and given the aid benefits the child. In Justice Wiley Rutledge's dissent of Everson, he states, "The court does not dispute, nor could it, that their use does in fact give aid and encouragement to religious instruction. It only concludes that this aid is not support in law. But Madison and Jefferson were concerned with aid and support, in fact, not as a legal conclusion entangled in precedents. Disregarding Trinity Lutheran Church's need for funding is religious discrimination, further confirmed by Rosenberger v. Board of Visitors in the University of Virginia. It has been made clear through these various rulings that First Amendment can and will protect the church's right for funding of a playground regardless of its religious affiliations."
What does it mean to establish a religion?
To establish a religion would be the government specifically picking one religion to make a federal religion or endorsing or showing preferentialism towards a specific religion. A good case of this would be Allegheny County versus ACLU, where there's a creche and a nativity scene that had a very specific Christian message on it. This message was right outside of the local courthouse in a very public area. This directly affiliated the government with a specific religion and therefore was a violation of the Establishment Clause, and is a great example of an establishment of a singular religion.
The First Amendment reads, in relevant part, "Congress shall make no law respecting an establishment of religion. Using the historical materials listed in this lesson plan and elsewhere, explain why the framers of the Bill of Rights wrote the Establishment Clause."
Well, first of all, many people came to America to escape religious persecution in Europe, as there have been many religious wars in Europe for many, many years. And after the 13 colonies were established and gained freedom from England, the Virginia Statute for religious freedom was disestablished the Church of England from the state of Virginia. This wasn't approved in the General Assembly until 1786, but once it was approved, it was incorporated into the Bill of Rights. Now, we still use the Establishment Clause today in many court cases, such as this one. However, and we understand separate church and state. However, instead, to decide this, we use the neutrality standard set under Lemons v. Kurtzman.
What is the origin of the concept of separation of church and state?
Well, the phrase is itself, the separation of church and state, was coined by Thomas Jefferson in a letter to the Danbury Baptist Association in the state of Connecticut. The concept actually came to fruition in Western thought during the Enlightenment. During the Enlightenment, it wasn't so much, or the beginning of the Enlightenment, it wasn't so much the idea of separation of church and state, but much more so religious tolerance, which was very progressive for the time period. A good example of a philosopher who believed this was John Locke. John Locke promoted religious tolerance in general, though would not go as far as separation of church and state. He does mention that magistrates should not use their power to control or persuade people to certain religious beliefs or ideas. It is no surprise then that Madison and Jefferson, both as adherents of Lockean philosophy, later go on to support the separation of church and state, a much more modern, for the time period, point of view. And a good example of this would be a group of men were locked up for their religious beliefs in Virginia, and Madison immediately went against this. He published something called the Memorial Remonstrance, which said that no government should have the power to discriminate against someone or lock them up on the basis of their religion. This issue was brought up again during the Philadelphia Constitutional Convention, where the argument of separation of church and state was very heated. Many religious groups wanted people to swear their allegiance to a Christian faith before being able to take a position of power or law within the government. Madison and his associates fought against this, and they wanted to have a separation of church and state. When later the Bill of Rights was added to the Constitution, it became part of the First Amendment under the Establishment Clause.
All right, what test should the court apply when assessing an Establishment Clause claim, and how would you apply that test in this case?
The court should use the Lemon test, which was later modified by the Agostini court case, which is Agostini v. Felton. What the Lemon test is a three-pronged test. The first is the government must have a secular purpose. The second is the government can neither advance nor inhibit religion. And the third one is no excess government entanglement. What is very important is that all three parts of these need to be met, or it is a violation of the Establishment Clause. As said earlier, this was later modified by Agostini v. Felton. What this did is it took the last two clauses, the advances or inhibits and the undue government entanglement clauses, and combined them. So undue government entanglement just became part of the second prong of the Lemon test. This is now our standard for applying all Establishment Clause court cases like the one we see today. Our Trinity Lutheran Church passes the Lemon test with flying colors, and it proves it is not a violation of the Establishment Clause, as, first of all, it has a secular purpose. The purpose being to make a safe environment for children to play on. Second of all, it also neither advances nor inhibits religion, because the government is not swearing any official affiliation or promoting any specific religion, as if this was passed, it would be neutral, and the process itself is secular in choosing which organizations get to receive the grant funding. It would be all religions would be able to receive this equally if they pass earlier qualifications. That religion would never be taken into account, so it cannot therefore advance or inhibit any specific religious organization. Third of all, there is no excess government entanglement. One of the big issues with Lemon v. Kurtzman was money that was being granted for schools. They weren't quite sure, where it was going, if it was being used for secular or non-secular purpose, and this is for private schools. And therefore, they had to constantly check up to make sure it was being used for secular purposes. This created a governmental entanglement, as in the government had to constantly check up on private funding on private schools and religious education, which has been defined as entanglement. Rather, here, though, it would be a one-time grant that would not need to be checked up on, because it is already allocated for a specific secular purpose, and therefore passes the Lemon test.
All right, what are the benefits of the state funding the Trinity Playground?
Funding the playground promotes a safe environment for children to play and grow in. And this should not be taken away from any child on the basis of religious discrimination. It's very important that all children, regardless of his or her faith, has the opportunity to have a safe environment to grow up and play in. And that would be one of the largest benefits of granting this money.
What are the costs of the state funding the Trinity Playground?
The cost would be merely monetary, as the government would actually have to pay the grant to all who pass the secular qualification process. But overall, this is of little importance in comparison to creating a safe playing environment for all the children who attend the daycare.
Should the state have any role in fostering religious organizations that benefit the community?
If the religious organizational activities are neutral and have a secular purpose and therefore don't violate the Establishment Clause, there is no reason why the state should not allow for the religiously affiliated organizations to benefit the community. If the organizations have met those requirements, as the Trinity Lutheran Church has, and other similar organizations should receive funding, the state should likewise give funding to the religious organizations so as to not discriminate, like under Rosenberger v. Board of Visitors of the University of Virginia, where the Christian publications were not given enough funding as the secular publications.